Welcome, and thank you for attending our first quarterly docket of the year. This is a quarterly review of all things compliance related to absence and disability. A couple of things to note before we get started. We are recording this session, and all registrants will receive a copy of that recording as well as a copy of the presentation slide deck shortly after the end of the presentation. If you have any questions, please use the chat feature and we will answer as many of those questions as possible towards the end of the presentation. Our presenters today are all from our own Reliance Matrix compliance team. Now I will turn it over to Marty Carty to get us kicked off.
Hey everyone, and welcome. So glad you could join us today. Before we get started on our quarterly update, I want to share with you some information about an upcoming fun event. One of our favorite industry conferences is the Disability Management Employer Coalition, the DMEC. And DMEC held its annual ADA FMLA compliance conference in March. And for those not able to attend or those who just didn't get enough compliance speak, the DMEC will present a virtual conference featuring the presentations of the top 4 rated sessions from the conference. And the date and registration information are here on this slide. It's featuring 2 of our compliance team members, Lana Ruprecht and Nell Walker. This is an entertaining but practical session with video clips illustrating some various scenarios, and those video clips are starring your favorite compliance attorneys and our staff. I can tell you, though, that most of us won't be quitting our day jobs for an acting role. The session is called Serious Health Condition or Serious Vacation, the FMLA in a Virtual Workplace, and Nell and Lana will identify issues employers face when trying to track and monitor FMLA abuse, manage intermittent leave, and support the honest belief defense in a virtual work environment. So hope you can join us for that. Thank you. And for now, I'm going to turn it over to Nell to go through our agenda. Thanks.
Thanks, Marty. Good day, everyone. To echo Monty and Marty, welcome to today's docket, Reliance Matrix's quarterly series highlighting key developments in the absence space. I'm Nell Walker, Reliance Matrix's VP of Product Compliance, and I'm pleased to join you today for my first live docket presentation. We've got a great agenda and panel for you today. First up will be Armando Rodriguez, our compliance counsel, with an update on recent developments on the state and federal legislative fronts. Following Armando, Shelby Felton, our PFML expert, will walk us through important updates to state paid family and medical leave laws and regulations. After Shelby, we've got Eric Brotman, our litigation expert, who will then share with us some recent regulatory and litigation developments and actions of note. Rounding off our panel topics today, Marty Carty, Reliance Matrix Leave Guru Emeritus, will walk us through an FML issue frequently facing employers: what to do when employees don't want to report time off as FMLA. Finally, time permitting, we'll wrap up with some Q&A. And with that, let's move into our program. Armando, take us away.
Thanks, Nell. So right now there's 2 main legislative updates I want to point out. The first one is the Pregnant Workers Fairness Act, and the second is going to be the Pump Act. The Pregnant Workers Fairness Act and the Pump Act actually were both signed into law on December 29th, 2022. The Pregnant Workers Fairness Act is effective as of June 27, 2023. Now, main concern is that it requires employers, covered employers, to provide employees and applicants with a reasonable accommodation due to their pregnancy, childbirth, or related medical condition. Like I said before, it's effective June 27th, 2023, and we do expect the EEOC to issue regulations before the end of the year. But they have issued some guidance already, and the links are provided right here. On the next slide, we have the Pump Act, which also has information, thank you, It was also signed into law on December 29th, and this one actually was effective December 29th. But starting April 28th, it provides employees with a private right of action with remedies including back pay, front pay, liquidated damages, and attorney's fees and costs. We have actually a blog post about the Pump Act, as well as various DOL resources that are linked here concerning the Pump Act. So now let's move on to the next slide. Here, we just wanted to share with you various items that we're tracking, Reliance Matrix, various trends that we're seeing. We've basically been tracking 358 bills since January 1st. As you can see there, we have 16%, that's roughly 59 bills from the various states on paid family and medical leave. The other bills that we have there can range from short-term disability, paid time off, jury duty. But as you can tell, we have all sorts of different leave reasons that are covered in this that we're tracking basically since January 1st. Every state is represented in this except for Idaho, New Hampshire, Ohio, Utah, Wisconsin, and Wyoming. So next we have Shelby talking about paid family and medical leave.
Thanks, Armando. So we're going to cover all things PFML now. And the first is our statutory map. This is our infamous resource, All Things PFML. If you click on each state, you'll get the particulars of each program, including who's an employer, who's a covered individual, contribution rates, and benefit calculations. And recently, we've been adding more detail on the private plan application process. Another map that we use is what I call our legislative map. This is the legislative tracking system we use to advise our clients. Every day, we track when new PFML legislation is introduced, how it travels through committee, if it's amended, if it passes, fails, or no action is taken when the session ends. A trend that we're seeing that I'll be pointing out more about later is states passing legislation that allows insurance companies to add PFML as a type of insurance that they can provide. That way, the state is providing a mechanism for PFML, but staying out of the business of actually providing the PFML. The map colors have changed slightly since our last quarterly compliance. What we have here now is green are mandatory states, and blue we've added as voluntary states. Yellow is pending of either variety. So I want to talk about some specific states, and the first are our group of new PFML states for 2023. Colorado and Oregon are clicking right along, as are New Hampshire and Vermont. And Maryland, I'll get into more later, huge change because they have put off their program for 1 year. If you'll notice at the bottom, we at the last quarterly compliance had one state that had passed family leave insurance as a class of insurance, and we have now added 2 more. So now we also have Arkansas and Tennessee. Those were passed during this legislative session. Getting into the specifics of Colorado. So we're right in the middle of our Colorado timeline. Employers have until Sunday to register on the My Family Plus employer portal. Contributions, first set of contributions are due on Sunday. This is the first time we're doing contributions in Colorado. And for that first time, Colorado is giving a grace period of 30 days. So at this point in time, employers will have to pay Q1 and Q2 contributions since no private plans have been approved that we're aware of. However, there's some conflicting advice from the state. So stay tuned for more information on our stat plans page about funding that first and second quarter. The October 31st, 2023 deadline to submit applications is a submission deadline, not an approval deadline. So as long as you have your private plan submitted by October 31st, you can seek reimbursement of contributions on your private plan. We've gotten some new clarifications from Colorado. First off, we have some new legislation. The governor signed Senate Bill 46. I've provided a link for that new, the new amendment is to average weekly wage. So you can click on that link. What it did was it changed where we're looking at for the average weekly wage. Before, we were looking at just the employer from whom they were taking leave. With the change in the statute, we're now looking at calculating that based on all employers for the last 4 of the last 5 quarters. I've also included a bunch of links because we have 3 new sets of proposed rules that have not been approved yet. The public hearing is at 5 p.m. Colorado time on May 15th via Zoom. I've provided links for those, and I provided links to each of the rule changes. What we're seeing under coordination of benefits, we're seeing some new when can different leaves run concurrently. Program integrity talks about enforcement. Under the job protection and retaliation, we have more specific definitions of those terms. And the last grouping of rules is for the appeals and investigations. More important, I think, is that we're still waiting for a rule change on application year. Family has given us indication that they're going to change application year from a rolling backward to a rolling forward. We're still waiting for this rule to be posted. Big news, we have submitted a fully insured policy for approval, but we and other carriers have not received any approvals yet. As those approvals come, the state is going to be posting them on the website. You can at this time, however, file your self-funded plan. I've provided links for that here, and I'm excited to say that the state is using the plan that Marty and I helped draft, and you can get that from your account manager. If we switch over to Oregon, Oregon is on a similar timeline to Colorado. So we have contributions due on Sunday. Unless you already have your approved equivalent plan, which there are several that have been approved in Oregon. We have our fully insured plan in Oregon as well as our self-funded. The next deadline will be May 31st. That's both to file a plan to be exempt from contributions beginning Q3. It's also the deadline to file for those of you that filed declarations back in October. If an employer filed a declaration and fails to submit a plan by May 31st, the employer is going to be responsible for contributions back to January, and they can't retroactively take those contributions from employees. We've also gotten some clarifications from Oregon. And again, I've provided links for everything on this slide. One of the major things we're watching is Senate Bill 11. Senate Bill 11 would give the director of the Oregon Employment Department the ability to actually delay the effective date of this plan. So as everybody knows, benefits are supposed to go live in September. If the division determines that the fund is not solvent, doesn't have enough money to pay benefits, then they can delay the program until December. They are supposed to, hopefully, provide a solvency determination by August 11th. So we'll keep our fingers crossed for that so that the plan goes live as expected in September. There are also 35 rule changes that are being proposed and have been posted for comment. The public hearing will be in June, and the rules should be finalized in August. The rule changes address benefits, things like addressing leave when an employee isn't scheduled for work, or more clarification on benefit reductions and tax withholdings. There's a group of rule changes to contributions and recovery. So what happens when benefits are paid? They made some corrections to the rounding for calculations, and they addressed debts and application of payments. Finally, there are some additional rules for equivalent plans, such as when the division can request information, some more clarification on appeal deadlines, and plan termination and withdrawal rules. So I really want to talk about Maryland. We were all excited. We thought Maryland was going live, but it is not to be. So we've got House Bill 988 and Senate Bill 828. Those went to the governor on April 10th of this year. The governor has said that he will sign this bill, and it's anticipated that he's going to sign it on May 3rd. It pushes contributions to begin October of 24 and benefits not to begin until January of 26. This Senate bill also says that the contribution rate has to be set by October of this year. So in Maryland, we still do not know what that contribution rate is going to look like. When it is posted, it will be effective from October of 24 to June of 26. Contributions are a 50-50 split between employer and employee. That split is subject to change. Contribution rate and the cost sharing formula will be reevaluated every 2 years. In this legislation, they also clarified that contributions will not exceed 1.2% of wages. Beginning in February of 26, they will calculate the total rate of contributions, and this is complicated. It'll be set for the next 12 months, beginning the next July. So we may still see further clarification and rulemaking on Maryland because some of it is a little complicated. They did add domestic partner as a family member, and they clarified the definition of wages in this new legislation. But now I want to see what we have conjured up for the future. Betty White, our dearly departed, is taking a look in her crystal ball, and what does she see for PFML? As I discussed earlier, we have several states that are adding a class of insurance for PFML. It includes Alabama, Florida, Minnesota, and Texas. It seems very likely that Alabama, Florida, and Texas are going to pass this. So similar to our states like Tennessee, we're going to be able to write that as a class of insurance. Delaware is clicking right along. We're waiting for more regulations. Louisiana has surprised us and popped up as a potential PFML state. Maine, we're still waiting to hear any word, despite the commission report having come in January. Minnesota is making its way through committee. I still want to point out that the first year in Minnesota would be funded by a surplus in the state's general fund. And Minnesota is a little bit out there because their leave is 12 weeks. So 12 weeks for a serious health condition, 12 weeks for family leave, plus 12 weeks for exigency leave. We also see potential for PFML in Pennsylvania and Texas, but what we're hearing is that neither of those states really have an appetite for a true PFML program. So we're really not anticipating either of those to pass. But thanks to Betty for helping us out, and I am going to pass it on to Eric for regulatory and litigation update.
Thank you, Shelby, and thank you, Betty, as always. So as Shelby mentioned, I'm going to be addressing our regulatory and litigation updates that have happened this quarter. So starting first with our regulatory updates, as you can see, it is the FMLA's 30th anniversary. Happy birthday, FMLA. You're finally a full-grown adult. And as a result of their birthday, Department of Labor has provided a few links on their website. There's an anniversary link where they tell worker stories and information that they've learned over administering the FMLA for the past 30 years. They've also updated their PowerPoint presentation on the FMLA, and there's a helpful link here, as well as updating their fact sheets on the FMLA, which are public fact sheets 28, A through Q, and a link to those fact sheets there as well. And then there's also a link to our blog posting on the 30th anniversary of the FMLA and what we've learned in administering this law for a number of years and how potentially we can revise it and refresh it to make it more applicable to today's situations. The Department of Labor has also put out some new field assistance bulletin guidance that was on February 9th of this year regarding telework, now that more and more of us are working from home instead of in the office. And this includes information on both how telework affects FMLA eligibility, as well as pumping at work, particularly as it relates to the FMLA. A lot of the field assistance bulletin guidance is on how you determine what work site an individual should be assigned to if they're working from home as opposed to actually working in the office. And again, we've also put out a helpful explanatory portion on our blog at the link below discussing the field assistance bulletin that the EEOC, or Department of Labor, has put out. Moving on to, I believe, is our last regulatory slide, is the opinion letter that the Department of Labor has put out regarding mandatory overtime. Here, opinion letters are where employers or anybody really could submit a question to the Department of Labor, and they'll, if they choose your question, they will put out an opinion letter sort of giving their best answer to that question. So here the question was about whether or not employees could limit the amount of mandatory overtime that they're required to work by using their FMLA leave. And essentially what the Department of Labor confirmed is that, yes, that the FMLA is an entitlement, that if an employee is otherwise eligible for the FMLA, they can utilize their FMLA leave to essentially indefinitely avoid working overtime. What the employer was really asking was, could it be treated more like an accommodation under the ADA, where you can take into account the undue hardship of an employee not working this mandatory overtime? But the Department of Labor said no. If the person is FMLA eligible, you have to grant them their FMLA regardless of any hardship that it might cause to the employer. Now, one more regulatory slide. So the EEOC has also put out some additional, not necessarily guidance, but just information and tips that have been refreshed regarding individuals with hearing disabilities, both a written explanatory resource, which explains the ADA requirements for individuals with hearing disabilities, as well as a YouTube video that you can watch, scintillating viewing, I'm sure, that explains the EEOC and ADA requirements regarding individuals with hearing disabilities. And now moving on to the exciting stuff, litigation. So first, we're going to talk about some pregnancy litigation. And our first case is EEOC versus Symphony Deerbrook. As you can see, there was a $400,000 settlement, a rather large settlement, as well as a consent decree. And what this case involved was that the employer here, Symphony Deerbrook, required pregnant employees to not only disclose their pregnancy, but also submit to a medical exam. And this was not a requirement that they had for non-pregnant employees. So essentially, the moral of the story here is keep your policies the same, whether it's for pregnant employees or non-pregnant employees, unless there's a compelling need for some form of difference. So here, if you're going to have a medical exam for employees, all employees should have medical exams, not just those that are pregnant. Now, moving on to our next case, EEOC versus Heartfelt Home Healthcare Services. Here, there's a $20,000 settlement, which is not a tremendous amount of money, but there was also, as there are in essentially all EEOC cases, the consent decree. And I don't want the consent decree to really be given short shrift. They can be fairly onerous for employers. They require not only enhanced training, but also changes to policies. And there's constant updates that you have to provide to the EEOC to make sure that you've complied with the consent decrees. So even though the settlement amount might not be much, you always want to take into account how difficult those consent decrees can be for running your business. But in this particular case, there was a pregnant employee with hypertension that was terminated because she was referred to as a quote unquote liability. I mean, I think this case essentially speaks for itself. Don't call pregnant people liabilities. Moving on to our last case here in the pregnancy space. Actually, it's one more. Sorry if we can go back. Thank you. EEOC versus AVI, C-Bar, and Chop House. Here, there was a $55,000 settlement as well as that consent decree. And here, the pregnant employee just simply requested a stool to rest on, and that request got her fired. Again, fairly common sense. If someone wants a stool when they're pregnant, give them that stool. And then moving on to our next case is just one other pregnancy case we wanted to highlight in the Western District of New York involving a correctional facility. Here, it's actually the ADA portion of the case was dismissed for reasons we don't need to get into, but under Title VII, the employee was allowed to move forward with their pregnancy discrimination case because the language and the comments used by the plaintiff's supervisor was just so harsh. And I just want to read that quote to you. Essentially, the plaintiff alleges that her supervisor said, quote, "I'm sorry that you're spotting, but if you don't come to work, you don't have a job. You know what? This is ridiculous at your age. Forget it. You don't have a job." And then they hung up. So really, the comments like that are so severe that regardless of what other facts you're dealing with, that's going to get you to a jury. So you want to make sure that you really discuss these things with your supervisors and your managers, and you train them in a way that they avoid any sort of hostile language like that. Moving on to the next slide. Now we're going to discuss some FMLA cases. So here in January, out of the Sixth Circuit, there's Millman versus Fieger and Fieger, which is a law firm. And here the employee wanted or had requested the potential for time off because of her sick child. And as a result, the employer terminated her. And in the case, they made the argument that, the employee never really said that they wanted FMLA leave, and it was sort of speculative as to whether or not they were going to take leave anyway. But the court said that that doesn't matter. As soon as there's the possibility of an employee needing leave that may be FMLA eligible, it's the employer's responsibility to really ask more questions, provide them their eligibility notification, and make that determination on full knowledge, not just on what you think might occur in the future. Moving on to our next case of Juday versus FCA US. In this case here, there was a question as to whether or not the employee that was utilizing FMLA leave was abusing their leave and taking it when really they weren't sick or ill, but just using their leave when they shouldn't. Here, the court found in favor of the employer, saying that an honest suspicion is the way the court referred to it in the Seventh Circuit, that was sufficient in order to take some sort of disciplinary action against the employee. What the plaintiff was really asking was saying is that there had to be definitive proof that the employer was required to conduct some sort of a surveillance. And although they didn't give a necessary burden, it was essentially that there had to be proof beyond a reasonable doubt that you were abusing FMLA. And the court said that that's not true. There just needs to be what's called an honest suspicion. What exactly that means in future practice, it's a good question. But at least it goes to show us that we don't need any sort of ironclad proof in order to discipline employees that we think are abusing FMLA. Moving on to our next case of McAlpin versus Town of Sneeds. This involved a sheriff that was, came under new leadership when a new city council was elected and had extreme difficulties with the city council. The city council terminated the sheriff a day after that sheriff requested FMLA leave. So naturally, the sheriff sued, claiming that it was FMLA retaliation and interference. But the court, the 11th Circuit, found that there was sufficient evidence that he was terminated for insubordination because of the difficulty that he had with following what the city council wanted. And so it just sort of reiterates the proposition that even though an employee is on FMLA leave or is requesting FMLA leave, if you have independent grounds to take sort of disciplinary action or terminate that employee, legally that's fine and that's sufficient as long as it's not based upon their request for leave. Moving on to our next case of Stevenson versus Parker Offshore, which is at the Eastern District of North Carolina. This is an issue we've dealt with before, but this sort of reiterates Again, the proposition that it's permissible for an employer to require an employee to make up time that they've taken off from the FMLA. That's not a sign of retaliation or of interference if you require employees who have taken time off under the FMLA leave to then make that time up at some point at a later period of time. Moving on now to the last case on this slide, Branch versus Navicent Health out of the Middle District of Georgia. Here, what happened was the employer provided leave to the employee under the FMLA, but there was a consultant that was involved here. There was an outside third-party administrator, and the employer really couldn't explain to the court who was it that made the decision to terminate this employee and what was the reason for the termination. So the court essentially concluded that if you can't tell us why this person was terminated, then the employee's claim that they were terminated for taking FMLA leave, that's enough to get to a jury. That a jury needs to be able to decide that because there's no evidence to the contrary here. So this really stands for the proposition that if you're going to take an adverse employment action against an employee, you really need to have your decision documented and detailed as to why you made that decision, so that if you do get in front of a court, you can credibly argue that it had nothing to do with their entitlement leave, that it had everything to do with employment reasons for business reasons, which would be a satisfactory reason for taking an adverse employment action. Moving us on to the next slide, some cases in the ADA space. Winters versus John Deere and Company out of the 8th Circuit this year. Here we found that there was no ADA violation for terminating an employee for conduct. Again, this reiterates the position that a request for leave or disability, that you can still terminate an employee for job-related reasons. We actually posted a blog about this because it was a fairly interesting set of facts here when the employee was out on leave and then came back, and there was a discussion about the employee's performance. The employee said, I'm going to fight you to the end, and it's not going to turn out good for one of us. That's what the employee said to their supervisor when having a discussion about the employee's performance. And that was essentially the reason, that and the poor performance, why John Deere terminated this employee. And again, the court found that since the employer could show that it was not related to the request for leave or request for accommodation, that it was an independent business-related reason, that the termination was valid and there was no ADA violation. Moving on to the next case of Brigham versus Frontier Airlines out of the 10th Circuit this January. And I know we've touched on this issue before. Again, the employee here was asking for a change in their duties to work light duties, but that would have been a violation of the collective bargaining agreement. And here the court found, as other courts have, that there's no need to accommodate when that leave request would violate a collectively bargained agreement, essentially under the argument that it would cause an undue hardship, that you're allowed to have these agreements with unions and that you need not violate them. On to EEOC versus United Parcel Services from the Middle District of Florida of this March. The EEOC was granted summary judgment in this case when an employee with diabetes, again, was called a liability and then terminated after asking for breaks. This case, fairly self-explanatory. Don't call employees with disabilities liabilities. That'll get you burnt every time. The next case, which I think is the most interesting of all the cases we're going to discuss today, is Bennett versus Hurley Medical Center out of the Eastern District of Michigan this January. The employee was asking to utilize a service dog in the workplace, which was a hospital. And at first, the hospital granted the accommodation on a trial basis. The individual used the dog, and then there were a number of not only patients, but employees who had severe allergies to dogs. And so the employer then revoked the accommodation and did quite a bit of work in making that decision. It was not only due to the allergies that people suffered, but also they submitted a report from their infectious disease department that dogs can be carriers of certain viruses that might make it dangerous in a hospital setting. And so the court agreed with the employer's decision, saying there was no ADA violation, in fact, granted summary judgment. And again, it was because of the a significant amount of work that the employer had done to show that this accommodation, although reasonable on its face, would cause an undue hardship not only to the employer, but its patients, and therefore the accommodation need not be granted. So the moral here is, if you're going to deny an accommodation because it's an undue hardship, you really need to be able to show what that hardship is and why it's so undue. You can't just argue, well, it's going to be difficult for us. That's not going to be enough. You really need to do the legwork and the background work to show that this hardship is going to be severe and it will cause significant disruption to the business. Moving on now to our last set of slides. It's an area that I think is really going to be, dominating courts for the next couple of years post-COVID, which is now that all of our employees are coming back to the office. A lot of them are asking for accommodations to work from home because we all did it during COVID. So I just wanted to highlight a few cases here that we've had over the past year or so, because there really aren't many discussing this request. So first we have Pateri versus Leotis out of the Southern District of Ohio. And here the employer was not required to accommodate the employee for an inability to commute to work. So I think these are interesting cases here. The employee had visual difficulties and wanted to work from home a couple days a week because they had difficulties driving at night and at certain periods of time. And essentially the court said that, commuting is not something that's required to do your job. That's an outside of work accommodation, and that's not something that employers are required to accommodate. And I just wanted to read you a quote from that case. Quote, while an employer is required to provide reasonable accommodations that eliminate barriers in the work environment, an employer is not required to eliminate those barriers which exist outside of the work environment. So essentially, it stands for the propositions that employers only have to accommodate those things that happen at work, not those things that get you to work or happen outside. Moving on to our next case of Baker Redmond versus Premise Health Employer Solutions. Here, the employer was granted summary judgment because the employer's job duties required physical presence at the job site. The employee here was a nurse. So you really can't do your job as a nurse unless you're present at the hospital or at the location where you're providing that care. So I just wanted to bring this up because the traditional analysis of whether or not something is an essential job function, presence at the office is still going to apply. If your job can only be performed at work, you cannot be given an accommodation of working from home. To the contrary, there's Lewis versus T-Mobile USA. And here, where the employee was previously allowed to work from home, it was a question for the jury to determine whether or not it's an essential function of being in front of customers, being at the work site. So I think this is really the question that's going to be coming up in the near future, whether or not being in the office is an essential function of the job. Whereas pre-COVID, it was fairly standard that courts would accept that analysis from employers. But I think that's going to come into question significantly now. And so whether, unless it's a job like the one before where it's a nurse and you have to be in the office, there really are going to be questions, especially if you were able to perform that job remotely previously, or if others in that same job category are performing remote work. And then our last case is a case coming out of the EEOC, Barrett versus Kijikazi, where here the EEOC held that an employer could choose to reassign an employee to a new cubicle instead of allowing them to telework, where the medical documentation stated that the employee needed, quote, a work environment that decreases distractions, including either work from home or a reassigned cubicle. So I wanted to point this out because employers really, just to reiterate the fact that you don't need to give the accommodation that's requested as long as you can find an alternative accommodation that solves the issue the employee is having. So if employees are requesting to work from home, but instead of working from home, you can give them a new cubicle, you can change lighting, you can provide different office equipment, depending upon what the issue is the employee has, you can solve that problem without granting a telework accommodation if you think it's important to have your employees in the office, even if it's just for 2 or 3 days a week. So with that, thank you for your time. I'm finished with this portion, and I'd like to hand it off to Marty.
Thanks, Eric. A lot of really important cases that you reviewed for us there. We really appreciate those summaries. In this segment of our quarterly update, we address a topic that we get questions on from employers, issues that employers we see are struggling with and are asking for some guidance. Today's lesson, as Nell gave us a preview of, is what do you do when employees don't want to report time off as FMLA, even if it's covered? Should be covered by the FMLA. And the reasons employees might do this include they want to save FMLA time for another purpose coming up, or it's too much hassle to report to an FMLA administrator, whether internal or external, too much hassle to get a medical certification or other type of cert that might be required to support the FMLA time. And so we're going to take a look at this. Why should an employer care if the employee is taking time off and not reporting it as FMLA time? Well, there's at least 3 possible negative consequences from the employer not being told that the employee's time is not having it reported as FMLA time. First is that you're not accurately counting time off toward the FMLA, the employee's FMLA entitlement. And so your employee may end up taking more time for an FMLA covered reason than they are entitled to and that you're required to provide. So that helps. That's a challenge with workforce management when your employees are getting more time off for a covered reason than you need to give them. Another reason that we care is that not giving the required FMLA notices at the start of leave or during an intermittent leave can constitute FMLA interference. So if you have reason to believe enough information to think that this might be an FMLA covered absence, those notice obligations kick in and you don't want to miss out on those. And then the third possible negative consequence about this is that if time is not recorded as FMLA time, as an employer, you might take disciplinary action against the employee for absences that should have been FMLA protected, either not count those absences toward your attendance policy or not reinstating the employee at the end of an FMLA leave. If you have not properly categorize the time as FMLA because the employee didn't report it that way, then you could have some serious consequences. So we're going to walk through a couple of scenarios to illustrate how this might happen and what you can do. For each of these scenarios, we're going to assume that your 2 employees, Janice and Richard, have been working for your company full-time for several years and have a lot of PTO time accrued. So we're not talking about absences here where the employee doesn't have some sort of entitlement to time off. That can occur too as well, but those are more complications, and we're trying to hone in on the key lessons here. So let's look at scenario 1. This is Janice. And Janice requests 4 weeks of PTO to visit her elderly father out of state. She tells you she hasn't seen her father in a while and wants to go visit him. But she also tells you that her father is moving into an assisted living facility. He can't really take care of himself very well anymore, and she needs to go help. You tell Janice that this is probably an FMLA covered absence, but she says she wants to save her FMLA for her own upcoming major surgery when she's going to need quite a few weeks off for that. So how do you handle this? Well, first off, you're on the right track, taking care of a parent moving into a nursing home, assisted facility, and so forth, or helping care for that parent with a serious health condition can be an FMLA covered absence. So you're headed down the right track. And as far as Janice saying she wants to save her FMLA time, this is not appropriate. The employer has the obligation to designate time as FMLA, and neither the employer nor the employee have a choice in that regard. If time off is covered by the FMLA, and the employee is eligible and has FMLA entitlement, then as the employer, you have no choice but to designate it, even if the employee wants to save up that time. And this is clear in the regulations, 825.301, but also in a DOL opinion letter from 2019, in which the Department of Labor specifically addressed this type of situation and said the employee cannot choose to delay their time off. So what do you do after you've given her the notices and you have advised her of FMLA rights and told her, no, you can't save your time? Then you want to get a certification from the father's healthcare provider. You have a right to the certification under the FMLA. And when you receive that, you want to make sure it's complete and sufficient and specifies whether how much of Janice's time off is going to be spent helping care for her father. You might have to rely on her word as to how much time she'll spend helping him relocate to an assistance facility. But you're entitled to the designation of how much that time off. Well, what if Janice says, I don't want to get a certification. I don't want to take this FMLA time. In that case, employers can waive the certification requirement and go forth based on information that you've gained from the employee or designated representative. But in this case, because she says she doesn't want to get a certification, one avenue that you can pursue is to tell Janice that you will apply FMLA to her entire requested 4 weeks off, because it sounds to you, based on what she has told you, sounds like FMLA time. And that if she wants not to have the entire time attributed to FMLA, she needs to get you that certification and talk with you about what portion of time is spent caring for the father through the certification support and what part of her time is going to be helping him relocate. And then once you get that certification, or you've followed this step where you tell her you're going to designate it all and she doesn't take any other action, and always do all of this in writing. Of course, you want to have a written record of what your conversations are and give her a chance to object to it, or give you other facts. Then you want to send that designation notice within 5 days of the time that you've received adequate information or have decided you have to go forward. So let's look now at scenario 2. This is Richard. And Richard already has an approved FMLA intermittent leave due to his migraines. So he already has given you that certification. And he usually takes 1 to 2 days off for intermittent migraines. That's been his historical pattern. But after a while, you notice that he is taking 1 or 2 days of last minute PTO occasionally, but not reporting any FMLA time. So you go to him, you ask him how his migraines are, and he says they're about the same. So because of that, you suspect that some of his PTO time is due to his migraines. What do you do so that you can appropriately attribute FMLA time as the rules require? Well, in the first place, you want to have a dual absence reporting policy. And the dual policy requires an employee taking time off for an FMLA covered reasons to report the absence from work so that the supervisor knows Richard is not going to be here on certain days, or report it late if it was an emergency, but report it, the absence itself, as an absence from work, and then a second reporting for the FMLA usage that the employee Richard here is taking time off for FMLA. And you want to remind Richard of the required dual reporting procedure, and then document your conversation, like I said before. Make sure he knows about it, remind him of it, give it to him in writing, give him a reminder in writing. If he still declines to report the FMLA time, these 1 to 2 days off occasionally as FMLA time, what can you do? Well, upon a new absence, I suggest that you inquire whether his 1 to 2 days off is due to a migraine. The rules, the FMLA regulations specifically allow an employer to inquire for more information from the employee when you suspect something might be FMLA covered, but you don't have enough information. So you can inquire, and if what happens next depends on what his answer is. If he says that his time off is due to migraines and he just wasn't bothering to report, or he forgot, or whatever, then you discipline in accordance with the reporting procedure. You don't discipline for taking FMLA time, but you discipline because he failed to follow the written procedures that you reminded him of. If he says no, these were not FMLA, these were other unexpected things that came up. And this happens a few more times. You ask him, he takes time off, you ask him, he says no. Then put it in writing that he told you that these absences on specified dates were not FMLA time. That way, and if possible, get him to sign it. You're not always going to be able to get an employee to sign something like that, but if you give it to them in writing and give them a chance to correct you, create the understanding that you expect this is what you understand and you expect them to correct you if it's wrong, at least you've got some sort of a written record. And then do you have to approve that FMLA time off? Well, if which path this follows depends on whether he said yes or no that the time off was due to migraines. If he continues to say no, he's not taking time due to migraines, you're kind of stuck there with his word for it. And despite your suspicions, you're probably not going to be able to attribute that time as FMLA time. You might consider getting a recertification to see whether the doctor says he's still having migraines, but that's recertification is another topic for another day. If Richard says, yes, he's still having migraines, then do you approve the time? You have the option for his failure to report of not designating the time as FMLA, denying it, but your goal is to get him to use his FMLA appropriately. And so you'll want to consider the facts of every situation, but you can go ahead and designate the time, even though he failed to report it or reported it belatedly. So just as a real quick recap on this topic, the things that you can take away here. You want to educate your employees on their FMLA responsibilities, and not only in individual circumstances, but up front. The FMLA has, the Department of Labor has an FMLA employee guide, which is really helpful. And it's not just the FMLA employee rights, it also brings home the employee's obligations to be entitled to those rights. And the poster, of course, you've got that posted in your workplace or electronically, but it never hurts. It's a good little summary to just give that to employees, again, if you're having issues or want to remind them of their rights periodically. Don't hesitate to ask the employee questions if you need more info, have that dual reporting procedure. And make sure that you're enforcing it, that your supervisors know that they're not to let this slide, that if the employee doesn't follow the reporting procedure, the dual reporting procedure to their reporting to them, if that's your process, make sure your FMLA administrator knows that if they don't report properly there, you're going to enforce it and impose consequences, again, for the failure to report, not for the requesting FMLA leave. And then designate that time off as FMLA once you have enough information from the employee or a designated representative that it is FMLA. Allow the employee the opportunity to object and provide other information. So that's our quarterly compliance lesson. I hope that was helpful, and we will turn it back over to Monty now.
Yes. Thank you, Marty. We had just a couple of questions. Both of them were related to the PFML states. So I'm going to toss these to Shelby to answer. The first question was that, Shelby, when you were speaking about Colorado, you mentioned that October 31st was the deadline for filing for a private plan in Colorado. Is an employer able to file a private plan anytime after that, or is October 31st the final deadline?
October 31st isn't the final deadline. You can continue to file for them. The October 31st deadline is when, if you file it by then, you can ask for a refund of the contributions that you've made into Family Plus, the employer portal.
Okay. And the next question also for Shelby. Shelby, when you were talking on the Colorado PFML, some of the changes that they had come out with, when you were talking about the application year, you said that they had changed the definition from measured backward to measuring forward. What exactly is that measuring?
That's measuring the application year. So when an employee files for benefits, the way they originally had it was that you would look backwards to see what benefits had been used in the last 12 months. What they're doing now is they're changing it to a look forward. So the application year will look forward So from the date that you take leave, you look forward and you get 12, within that 12 months following, you get however many weeks you need, up to 12, plus additional for pregnancy complications.
Gotcha. That is all of the questions we had, unless there's any more last minute ones that have come in. And with that, we'll be closing our first quarterly docket. We hope you found this information helpful, and encourage you to all have the best rest of the week.